does somebody need to make a will? Why can they just not manage without one?
Where to start? We are all going to need a will one day. People don't always appreciate the range of things that you could actually cover in a will. It's somewhere where you can document your funeral wishes. If you're parents, it's somewhere where you can document who you would like to be guardians for your children if something were to happen to both of you. It's where you can document where your jewellery goes or your golf clubs or how you make gifts to charity. It's where you can do some broader planning. That might be planning around care home fees and what kind of impact that might have on your estate. And broader tax planning. There are structures that we can help put in wills that, where possible, minimise the impact of inheritance tax. So they have big planning reasons for them as well. And it's a way of making sure you've got adequate provision, especially if you've got a complex dynamic in your family. Perhaps if there's a second marriage and there are stepchildren, how is that all going to pan out if you don't have a will? So very broadly, it's how you make sure that what you want to happen is what happens and how your family is provided for the way that you want. And Anne, you began by saying, what happens if you don't do it? Well, if you don't do it, the law can fix most things, and it fixes that particular problem with the intestacy rules. So if there is no will, you look at the intestacy rules, and that tells the world what will happen to your estate. And broadly speaking, those rules protect a spouse who is there, and then blood relatives. So if you're not married or in a civil partnership, but as is increasingly common, living with somebody, that person without a will is highly likely going to receive nothing under the intestacy rules. So really important for people who are in relationships that fall short of that formality we associate with marriages and civil partnerships.
You touched on earlier about tax planning, that efficient wills can perhaps help to mitigate tax. Presumably, in the absence of a will, the intestacy rules may not work in your favour from a tax perspective.
Well, absolutely. So, yeah, I said there's a way of sorting it all out. We have got some intestacy rules, but they very rarely work to a family's advantage, whether that's on a personal level or a tax planning perspective. And I was talking about a particular example of if you're not married or in a civil partnership. But the way the rules work, even if you're married and there are children, the rules say that the children are going to inherit part of the estate. And depending on the values of the property in the house, that could leave the spouse vulnerable to not being able to remain in the matrimonial home. So, yes, there's a fallback position, but I say to all of my clients, don't go there. Don't leave your family navigating the complexity of the intestacy rules. We are all going to need a will one day. And it really is never too soon.
I understand that you've been talking about the need for people to make wills, and certainly whilst we've had this current difficulty with people being in lockdown and the social distancing that people have had to comply with, so how are we able to get around that so that people can put the wills in place that you've just said how important it is that they do that?
Yeah. Well, we have got increasingly inventive over the last several weeks of lockdown. The process of executing a will is subject to some pretty rigid formalities. It has to be signed by the person who's making the will in the presence of two completely independent witnesses who can see that signature going on the page. They are both present at the same time, and they both then sign the will afterwards, which initially sounds like a bit of a mountain to climb when you're in lockdown, or at best subject to a 2-metre distancing rule. In practice, there are ways of dealing with that, and I can speak to that, and I think most of my colleagues now have practical examples. We've had one instance of a lady driving to our office and sitting in her car and signing her will while two of us were outside watching the process. And the will then got posted out through the window, and everybody was wearing gloves and nobody was sharing pens. I have met clients on a driveway with a makeshift Black & Decker workmate table and executed the will that way. And in other cases, we've sent the documents out to our clients entirely. We've not been there talking them through the process, but we can explain it in writing, what signature needs to end up where. And they've then been passing things across the garden fence to the neighbours. So there are ways of achieving this. So if you haven't got a will and you are thinking about doing it, don't let the current difficulties put you off. We can help you find a way around that.
I guess moral, Virginia, is where there's a will, there's a way.
Thank you for that, Anne.
Sorry, Virginia, I was going to ask a question. You talked about being in the presence of the witnesses. Could you witness a will over Zoom or video chat or something like that? Does that work or not?
I've avoided it. And you might come in on that one as well. There is discussion about it. I don't want to do anything that could be subject to challenge. And I've managed somehow or other to get people in the same presence. But Anne, what do you think about that?
I think that our view is that if it was a desperate situation and you had somebody that was terminally ill and you had no other way of doing it, then I think we would try absolutely everything we could to get a will signed and properly executed. And then if we had to, we'd perhaps try and put a case together to explain why the circumstances were such that it was signed in such a way. I know that there have been other jurisdictions, for example, in New Zealand, that they've been a lot more flexible than we have. But currently my understanding is that our rules are still quite prescriptive, and they're very, very old rules, and they still apply as Virginia has just explained. Unfortunately, Andrew. Yeah,
and I suspect no one wants to be the test case, because a test case is probably going to be very expensive.
Indeed. I mean, I expect that when we're out of the other side of this, and there will be some, and I know that's your area, so you'll be able to let us know. But I'm sure that somebody will be, but it's going to cost a lot of money, I would imagine. So it's going to need to be a fairly sizable estate to justify any litigation. Yeah. The other thing, Virginia. Whilst people are self-isolating, I know that there's been problems with people being able to get things done, their transactions, their financial transactions. So I wonder if you've got any advice for people that perhaps need somebody to do things on their behalf, how they go about authorising somebody to conduct their affairs for them.
Well, something we advise all our clients to do is to prepare lasting powers of attorney. And some of our clients will have those in place, and some of them, from a property and financial affairs perspective, will have set them up so that they can be used even while they still have mental capacity if they want some help directly. So some people might have those arrangements in place already. If you don't, and it does take quite a few weeks to get that process set up, we can create for our clients what's called a general or an ordinary power of attorney, which is very specific. Usually you can limit it to the particular thing you want somebody to sign, the particular task that needs doing. But we can put in place a power of attorney that will cover specific tasks that might need doing now. So again, don't be put off if there's something that you need help doing.
And they're quite easy to do, Virginia, aren't they? Whilst, as you said, the lasting powers of attorney, the court require certain requirements for those, and they can take several weeks from start to finish, but they're still very important in the long run. But as you say, with the general powers of attorney, they can be done, as I understand it, straight away, and so there is an advantage, and for peace of mind they can be done possibly whilst the lasting powers of attorney are trending on and getting completed.
That's absolutely right. Yes, I think we've all done that on occasion. So that, they can be set up very quickly, and very often they do have a place being set up while you're waiting for the long registration process with the Office of the Public Guardian to be completed.
I guess I should say that the only drawback is with the general power of attorney is if somebody is losing or has lost capacity, then obviously they can't be used, which is why if somebody has capacity, we normally recommend, don't we, Virginia, that they do a lasting power of attorney, because that will still endure beyond their incapacity, but in the short term do the general power so that they can get it up and running and doing whatever they need. Yes, that's a good point, Anne. And actually it dovetails back to, I think, what I was saying at the end of talking about wills. Same for lasting powers of attorney. The sooner you get on and get these things in place, the better protected you are, the greater your peace of mind, the less worry and trouble for your family might lie ahead. Yeah, absolutely. Thank you, Virginia. Very wise words. Thank you.